So in this lesson, we are going to be moving away from learning about legal authority itself into something much more practical. And that is how legal professionals actually conduct legal research in the real world, okay? And honestly, this is where a lot of students finally kind of begin realizing that legal research isn't just about finding cases in a database. It is a process. It's a strategy. It's a method of thinking. But here's the reality. Most legal research projects, they don't actually begin with like a perfectly organized legal question. All right. They begin with some confusion, right? A client calls a law office upset and emotional. An attorney walks into your office saying, "Can you see if we have a claim?" A judge asks for additional briefing on like an issue that nobody anticipated. A supervisor sends, a vague email with 3 sentences. And then Reese says, research this. This is real legal practice, okay? And it's honestly one of the biggest transitions that students kind of have to make, and that's in learning to move from messy facts to organized legal analysis, and that process is what takes structure, okay? So, some will often assume initially that strong legal researchers immediately just kind of know where to look. And that's not the case, right? Experienced researchers simply know how to break problems apart systematically. All right. So they begin asking questions like, what area of law is involved? What jurisdiction matters? What legal issues actually exist? What facts are legally significant? What authority is controlling, right? So these questions help to transform that chaos into researchable issues, okay? And that's one reason why legal research kind of becomes intellectually challenging. The hard part is often not actually locating the authority. It's identifying the actual legal problem correctly in the first place, right? So imagine you have somebody who's like, my rights were violated. Well, that statement alone tells you pretty much nothing, okay? But a researcher would immediately start narrowing. Well, who violated the rights? Was government action involved? What right? What facts exist? What jurisdiction applies? What harm occurred? Things like that. So good legal researchers learn how to ask those focused questions before they start searching. Okay. Another important thing that you should understand is that legal research is rarely perfectly linear. Okay. Sometimes students will expect like step 1, and then step 2, and then step 3, and then the answer is complete, right? But real legal research usually loops continuously. Okay, so you might find a case that raises another issue, or a statute that references another, statute, or a constitutional question that creates a procedural problem that you hadn't anticipated. Okay, and this is why flexibility kind of becomes one of the most important legal research skills, because the law itself is so interconnected, right? One more thing is that students often underestimate how much strategy exists inside of the research itself. I'm so sorry, I had to pause and sneeze. So researchers constantly evaluate how much time is available. How deep does the analysis need to go? Like what resources exist? What jurisdiction matters? How current must the authority be? And a quick preliminary office memo requires, different research than something like an appellate brief or a constitutional challenge or a trial motion that involves some sort of complex litigation. And honestly, understanding the research process is what begins transforming students from like passive information gatherers into actual legal analysts. So one of the most important things that you're going to learn in legal research, again, is that flexibility exists in research strategy, but certain ethical obligations are absolutely non-negotiable, okay? So this slide actually identifies 2 of the most important rules that researchers must always follow. One is checking supplements or pocket parts, and then validating authority through shepherdizing or key citing, okay? And these rules exist because the laws change constantly. So students sometimes assume that once they find a statute or a case, the job is done. And that's not even close to the truth, okay? And that's because a case that was an excellent authority, say 5 years ago, might now be overruled or limited or distinguished or, criticized or affected by, later legislation today, all right? In the same way that statutory language may have been amended recently without researchers realizing it. So imagine preparing a motion like relying heavily on a criminal procedure statute that changed 6 months ago, or citing a constitutional case that was overturned by a higher court. That creates very serious professional problems immediately. And honestly, judges notice these mistakes. Okay, nothing damages legal credibility faster than very confidently relying on outdated authority or hallucinated authority by AI, but that's a whole different issue. Now, sometimes people hear the phrase pocket part and they think that it sounds ancient. And honestly, in a lot of ways, it's connected to older print research systems. So before online databases updated statutes electronically, legal books were supplemented physically through inserts placed into the backs of the volumes called pocket parts. All right, so researchers had to verify whether statutory language changed since publication. Now we have technology that has evolved, right? But the same underlying principle still remains exactly the same. You have to verify authority in its current state. All right, so that obligation never, ever disappears. Now let's talk about shepherdizing and key citing. Because honestly, these are some of the most important research tools that legal professionals actually use, okay? Both of these systems help researchers to determine whether authority remains valid and how later courts treated it. So like imagine finding a case supporting your argument perfectly, right? Without any kind of validation, you have no idea if later courts followed it, if they limited it, did it get overruled entirely, was it just criticized? But not doing this is dangerous, okay? And students sometimes become overly dependent on, symbols or color indicators inside of the legal databases. Like they see a red flag or a yellow flag or a green symbol or a stop sign, that type of thing. Good researchers are going to go deeper than that. They're actually going to examine how later courts discuss the case, like whether the legal issue changed and whether the relevant portion of the opinion remains valid. Because sometimes a case can be partially overruled while other sections remain perfectly good law. Okay, and that's another reason that legal research requires very careful analysis rather than just shortcuts. Now, technology does help tremendously. But again, critical thinking still matters. All right. So you have to understand that ethical research obligations, these connect very directly to competent representation. All right. Clients are trusting the legal professionals to provide this accurate legal analysis. And that trust creates professional responsibility. And this is why research mistakes can have very enormous real-world consequences, and they can involve, criminal convictions or, custody disputes, financial losses, all kinds of things, right? So it's not just academic work. This is work that affects real people's lives. So one of the hardest parts of legal research for beginning students is figuring out how to start searching effectively. Students will often sit down at a database and type something extremely broad like, can employers do this? Or illegal search rights. And that usually creates either thousands of irrelevant results or almost nothing at all useful. Okay? Strong legal researchers learn how to translate messy factual situations into legally meaningful search terminology. All right? Honestly, this skill becomes one of the biggest differences between inefficient research and targeted research. Okay, so like this slide specifically focuses on asking foundational questions: the who, the what, the where, the when, the why, and the how. And those questions sound very simple initially, but they're incredibly powerful analytically. So like imagine if somebody says, my boss fired me after I posted something political online. All right, well, immediately a researcher can start breaking that problem down. Well, who was involved? Private employer or government, employer? What's the issue? Is it free speech? Is it employment discrimination, wrongful termination? Is there a contract violation? Where did this occur? State law matters enormously when it comes to employment cases. When did this happen? So timing might affect statutes and procedural deadlines and any kind of recent legal developments. And then why did the conflict develop? Was this speech disruptive? Was it political? Was it harassing? Was it connected to workplace policy, right? How did the termination happen? Was there formal discipline? Was it retaliation? Is there social media policy enforcement? All those things, right? But you can notice how quickly one vague factual situation becomes multiple possible legal questions, all right? That process is legal analysis beginning to happen. All right. And again, sometimes students underestimate the importance of terminology in legal research because law has its own language, right? Researchers must learn terms of art, essentially. Okay. So for example, a client may describe being punished for speaking out. Well, legal researchers need to search concepts like protected speech, retaliation, let me think, whistleblower protections, adverse employment actions, or even First Amendment claims, right? Those differences matter enormously in the databases, okay? Now, one thing you should also understand is that the facts determine legal significance. So tiny factual differences can completely change the legal analysis. So imagine that two people are claiming unlawful searches happened, right? But one involves a public school locker, right? And the other one is a warrantless cell phone search during an arrest. All right, both involve searches, but the legal framework differs dramatically. So a good researcher learns how to isolate legally significant facts early on, okay? And this is one reason why experienced legal professionals ask so many questions before they actually dig in and start researching, because better factual understanding creates better search strategy. Now, as researchers begin organizing their legal problems, there are a few foundational questions that will help to narrow that analysis significantly. And honestly, one reason that beginning researchers become overwhelmed is because they try researching everything instead of narrowing very systematically, okay? So as we can see here, we have 5 major considerations. One is whether the matter is civil or criminal. The jurisdiction, what's the cause of action? What are the defenses? What are the remedies? Okay? So starting with the criminal versus civil, sometimes students will blur these categories initially, but criminal law involves prosecutions brought by the government for violations of criminal statutes, and civil law is generally going to involve disputes between individuals, businesses, and or organizations, and they're looking for remedies like money or injunctions or declaratory relief. Okay, so that distinction matters because procedure differs, burdens of proof differ, constitutional protections differ, and available remedies differ, okay? So imagine that somebody physically assaults another person. The government can pursue criminal charges, but the victim can also file a civil lawsuit for those damages. So you have the same underlying event, but different legal systems with different goals, okay? Jurisdiction becomes important immediately, because researchers have to determine what court has authority to hear it, what law controls, okay? Then you have to identify the legal action itself, like what claim actually exists. Is it negligence? Is it breach of contract, discrimination, or constitutional violation, assault, wrongful termination? The list goes on, okay? And sometimes students kind of jump straight to conclusions without properly identifying that legal cause of action first. And that will create very weak research quickly. Okay. Another major issue involves defenses, and that every legal claim potentially faces defenses. So, for example, self-defense or consent or immunity or statute of limitations or comparative negligence, qualified immunity, constitutional privilege. Again, the list goes on. Good researchers are never going to analyze only one side of the dispute. They're going to evaluate the claims and the counter arguments simultaneously. All right. Now, researchers must also consider remedies. Like, what is the client actually seeking? Do they want money? Do they want an injunction? Do they want suppression of evidence? Do they want their custody modified? Whatever. Okay. Remedies shape litigation strategy like big, okay? Clients will often misunderstand what courts can realistically provide. A client might want revenge or an apology or moral vindication or some sort of public accountability. But courts operate through legally recognized remedies. So understanding that distinction matters in legal analysis and client communication, not just because, really, you know what? At the bottom line, it helps to set the client's expectations. Now we're moving into something that students usually want very immediately, and that is, how do I actually research efficiently without drowning in information? And one of the biggest mistakes that beginning researchers make is assuming that good legal research starts by immediately searching random cases in a database, and usually it shouldn't, okay? Strong researchers work strategically. So they're going to begin by orienting themselves to the issue before diving head first, into some sort of complex primary authority. All right. This is why secondary authority becomes so valuable early on in the research process. So imagine that you're assigned, a research project involving adverse possession. Okay. And you barely remember what that doctrine even means. If you jump directly into appellate opinions, immediately, you can feel overwhelmed because cases assume that readers already understand the doctrine, the terminology, the elements, and even the historical development of it, right? So this is why legal encyclopedias are really good starting points. Encyclopedias will help researchers to understand concepts, to identify terminology, to locate, leading cases, and even to organize the issue more broadly. Okay. Think of them almost kind of like an orientation map. Okay. And experienced researchers use these sources constantly. Students sometimes think that using secondary authority is weak, but it's not. It's actually very efficient. And it's something that should be relied on, more heavily. Now, another important strategy is it involves examining the statutes early. Sometimes students can become, overly focused on cases while ignoring the statutory language entirely, and that's dangerous. Many legal issues begin with statutes, so like your criminal offenses, your employment protection, administrative regulations, all of those things are very heavily statute driven. Okay. This is why annotated codes become very incredibly valuable. The annotated statutes don't simply provide the statutory language itself. They also provide references to cases that interpret the statutes. You have related authorities, you have secondary sources, and even procedural cross-references, okay? So the annotation structure saves a lot of research time. Now, imagine reading like a criminal procedure statute that involves a warrantless search. So the statutory language might appear relatively straightforward initially, but the appellate annotations may immediately reveal that there's a constitutional limitation, or there's some sort of conflicting interpretation. You might have some leading precedent or even some sort of procedural exceptions. Without those annotations, your understanding would remain incomplete. Okay? Another important thing that you should understand is that if annotated statutes do not produce sufficient authority for you, then researchers will often move into the digest systems. And digest systems become extremely important because legal databases are only as useful as the search strategy behind them. Okay, so digest will organize the legal concepts by subject matter and key topics. And that helps researchers to locate cases systematically instead of relying entirely on, keyword guessing. All right. And then we have the treatises. So, a strong treatise is written by experts in the field, and it can provide, historical context and strategic insight, a deep analysis, development of the doctrine, things like that, even extensive citations to the authority. So like if you have a constitutional law treatise, it will often explain not just what the rule is, but how did we get there? Like, how did it evolve? Why do courts disagree? And where, this doctrine might actually be moving. And that gives a more broad understanding, and that matters, tremendously to the research itself. One reason that experienced researchers do become efficient over time is because they stop treating research like random searching. And again, instead, they're learning how sources connect together more strategically. All right, so as legal issues become more complicated, researchers are often going to need sources that provide more broad context and a deeper analysis. This is where resources like ALR, annotations, legal periodicals, loose leaf services, and citators become incredibly important. And honestly, students often underestimate how layered, sophisticated legal research really becomes. Again, one source leads to another, one case reveals another issue, one annotation uncovers, a jurisdictional conflict, right? One law review article predicts an emerging legal trend, right? So research becomes almost investigative. Now, let's talk about ALR, which is the American Law Reports. These annotations are extremely useful because they collect and summarize cases nationally involving highly specific legal issues. So if you're researching like whether schools can discipline students for off-campus social media speech, so an ALR annotation might summarize how different jurisdictions approach the issue, where courts might disagree, what constitutional concerns might, come up from this, and what national trends are developing. And this saves a lot of time, okay? And one of the reasons why ALR becomes so valuable is because modern legal problems often develop very unevenly across the jurisdictions. So the different courts can interpret the similar issues differently, and ALR helps researchers to identify those patterns very quickly. Another important source are the legal periodicals and the law review articles. And this is where legal research starts becoming very deeply analytical rather than simply procedural. So the law review articles often explore like controversial legal questions, unresolved constitutional debates, emerging technology issues, policy concerns, and evolving doctrines, So if you have scholars that are discussing, say, AI generated, evidence, or like social media liability or deep fake regulation, they would be doing it in these law reviews long before courts fully address those issues. That means that legal scholarship sometimes predicts where the law might eventually land once it's evolved. Another source is the loose leaf service, and these are especially valuable in a very fast changing area of law like taxation or securities regulation or employment law or administrative law. And the reason being is that those areas change constantly through, new regulations, new agency guidance, administrative rulings, and statutory amendments. So researchers need those resources updated continuously. Now let's shift back to shepherdizing and key citing, because honestly, no matter how good your research appears initially, it's not finished until the authority has been validated. And sometimes people think that validation is a final, technical step, but it is way more important than that. Validation is going to protect the researchers from relying on, the overruled cases, the amended statutes, weakened precedent, outdated doctrine, all of those things, right? And that's another reason that legal research requires patience and discipline. You cannot rush competence, okay? Strong researchers verify everything. And I mean everything carefully, because legal analysis, again, it affects real people's lives, their rights, their finances, their liberty, all of it. So one of the smartest research strategies that legal professionals use is also one of the simplest, and that is just ask questions, okay? Sometimes people resist this initially because they think asking for information or help makes them appear, unprepared or inexperienced, but experienced legal professionals are asking questions constantly. We're talking about to their colleagues, supervisors, librarians, clerks, experts, other attorneys, things like that. Because legal research is not a solo performance, all right? It is often a collaboration for problem solving, okay? Now, one of the biggest mistakes that inexperienced researchers make is spending 6 hours struggling, alone, when it could have had a 5-minute conversation take care of it, right? It could have pointed them to a leading case or the correct statute or even the best secondary source to check, right? And that's not efficiency. That is fear disguised as independence, okay? So now this slide uses the acronym JUST ASK. And honestly, every part of it kind of reflects the practical legal research strategy, okay? So first you have to ask jurisdiction very carefully. Is it state? Is it federal? Is it administrative? Is it a local ordinance, right? Jurisdiction changes everything. Then researchers should follow useful leads by asking knowledgeable people for guidance, all right? So legal professionals love shortcuts that save time, and an experienced attorney may immediately know something like the controlling case or, again, the most respected practice guide, for some sort of particular issue. And that information is very incredibly valuable. Next is scope. And that means what exactly does the supervisor want? All right. This becomes very critically important because sometimes people will over search, or under search for their what it is they're looking for dramatically. Okay, or I guess I should say over and under research. But imagine that you have an attorney who's asking for a quick preliminary overview. That attorney doesn't want some sort of 47-page constitutional history. They just want an answer, right? So a complex appellate brief absolutely may require a historical development, policy concerns, deep analysis, extensive precedent review, things like that, right? But a good researcher is going to tailor their depth appropriately. Another thing is that they should understand is terminology, which is the T. So legal language matters a lot. All right, a client may describe being punished unfairly. All right, legally, researchers may need terminology involving, retaliation or due process or constitutional deprivation, things like that. So terms of art, they shape, search results dramatically. Now, another thing that students underestimate is how often acronyms actually appear in legal practice. And legal professionals love they love acronyms, like FMLA, ADA, OSHA, FERPA, HIPAA, ERISA, UCC, FOIA. There's tons of them, right? And misunderstanding an acronym can actually derail your research very quickly. And then finally, you have to think about your practical constraints, right? How much time is available, what budget exists, like how many billable hours are realistic. Legal research happens inside of business realities too, and clients cannot always afford unlimited research time. So a strong researcher has to learn how to balance through, thoroughness, efficiency, strategy, and cost. And I just realized I absolutely missed the S down at the bottom and ask what sources might be of help. Again, we've already talked about that one kind of ad nauseum, so I'm not going to harp on that one. Now, one of the biggest mistakes that students make during legal research is assuming that they will remember everything later. And honestly, you won't. And you shouldn't, right? That's completely normal. Legal research quickly becomes information heavy. So researchers are going to be reviewing like dozens of cases and statutes and annotations, procedural rules, and even like secondary sources all within a single project, right? So without organized notes, everything starts blending together. So poor note organization creates enormous inefficiency later. And people often experience this exact problem. Like they remember reading something really helpful somewhere, like a really helpful case or something, but they can't put their finger on it, right? They can't put their finger on the citation or the holding, the jurisdiction, or even why it mattered. And that creates frustration immediately. So this is why strong researchers develop disciplined note-taking systems. All right, so one of the most important things that researchers must always record is the complete citation. All right, because legal authority has to be traceable and it has to be verifiable. And without accurate citations, then researchers may struggle later to locate that authority again, to shepherdize it even, or to cite it properly when, using it in legal writing. Now, another critical component does involve summarizing the facts. And honestly, facts matter far more than you might actually realize initially. You can have two cases that involve similar legal issues, but they produce completely different outcomes because of the factual distinctions. So this is why researchers, should capture who was involved, what happened, what procedural posture existed, and what facts drove the court's reasoning. All right. Procedural history, that matters too. Sometimes people will skip procedural posture because it feels, technical initially, but procedural context often shapes legal outcomes significantly. So was the case a motion to dismiss or a summary judgment? Or was it a criminal appeal or a suppression hearing or some sort of constitutional challenge? Again, the context matters. All right. Another important part of research notes involves identifying. We need to identify the issue, the reasoning, the holding, all of that. The issue is going to explain what legal question the court addressed, because remember, we're not relitigating everything, right? The reasoning explains how the court analyzed that issue, and the holding is going to explain the actual legal conclusion that was reached, all right? And sometimes reasoning and holding can be confused initially, but the holding is the rule or the outcome. The reasoning is the explanation behind it, all right? And understanding both of those is going to become incredibly important because later courts can follow law, they can distinguish it, it can narrow it, and they can even criticize the reasoning differently than the holding itself. Now, one more thing when it comes to your organized notes and saving time. It's going to help you when it comes to drafting memoranda, preparing motions, creating outlines, or even just discussing the cases. So those strong notes are going to turn, research into usable work product, okay? And experienced legal researchers often spend almost as much time and effort organizing information as locating it in the first place. Because again, organization is ultimately what makes the research useful. Now, one of the absolute hardest things for beginning researchers is to learn is like knowing when enough is enough, okay? And honestly, students often assume that strong researchers just keep researching forever until they read every possible source that exists, and that's not realistic, okay? At some point, legal professionals have to stop gathering information and start analyzing and writing and strategizing and making decisions, all right? And this becomes especially difficult because legal research can feel endless. All right, every source is going to lead to another source. Every case is going to lead to another case, and every statute is going to create another possible issue. So researchers can disappear down research rabbit holes very easily. All right. And this has happened to inexperienced legal professionals too, at times. You know, you start researching one constitutional issue and suddenly 2 hours later, you're reading historical law review articles from 1974, you know, and maybe even Supreme Court footnotes involving doctrine that nobody even asked about originally. It happens, all right? Now, one major sign that researchers may be reaching an appropriate stopping point is repetition. So if you keep encountering the same leading cases, the same statutory interpretations, and the same, analytical themes repeatedly, that usually signals the major authorities have already been identified. All right, so in other words, this research landscape is going to start stabilizing. All right. And you might think, but what if there's one perfect case I haven't found yet? All right. Let me tell you, honestly, I've been there, and that fear can create paralysis. Okay. Strong researchers eventually learn that legal research is about reasonable thoroughness and competent analysis and not some sort of mythical perfection. All right. Another important sign is whether or not news sources are actually adding meaningful information. All right, so let's say that you've read, 5 different secondary sources that are discussing all of the same exact constitutional rules without introducing anything substantially new. Well, at some point, additional reading is going to stop producing value. All right, now that doesn't mean that the issue suddenly becomes unimportant, but it means that it's already been identified, like the controlling authority, any kind of relevant interpretations or some sort of, major analytical framework. It's been identified. All right. Another important stopping point is going to involve validation. And researchers should stop only after shepherdizing or key citing ends up giving no major changes affecting the authority that's being relied upon. All right. And honestly, this is one of the most important ethical safeguards in legal research because finding authority is not going to be enough. Researchers have to confirm the authority actually remains valid. All right. Another thing you should understand is that I was going to say the right amount, but it's really the quote unquote right amount of research. It depends heavily on context. So like a quick office memo can require very limited, preliminary analysis. But again, that constitutional appellate brief is going to require so much more. We're talking, extensive historical research and intense analysis and policy examination, things like that. A trial motion that's filed under an emergency deadline might require some sort of fast, targeted authority rather than, this exhaustive scholarship that you would be giving. All right. Good researchers adjust their depth appropriately. And honestly, this is one reason that communication with supervisors matters so much. Again, sometimes people are very dramatically over-researching assignments because they misunderstand expectations. So an attorney asking, can you quickly see whether there's support for this argument is not necessarily requesting like a very comprehensive 50-state survey, and constitutional history. One other thing, though, that I want to leave you with that you'll eventually learn is that certainty is not always possible. Sometimes authority is going to be in conflict with other authority. Jurisdictions are going to, disagree. And then legal questions, they're just going to remain unsolved. And at some point, researchers have to synthesize the best possible authority and move forward analytically. All right. And honestly, that transition right there from endlessly gathering information to confidently analyzing it is one of the biggest developmental steps in becoming a strong legal researcher. And that brings us to our last slide. And as we close, I want to focus on something important. And that is that good legal research is not just about intelligence. It is largely about habits. And honestly, students sometimes assume that strong legal research are simply people with extraordinary memories or natural brilliance. And usually they're not. 100% usually are not. Strong researchers are often people who develop disciplined, adaptable, organized research habits over time. All right. So this particular slide right here, it lists several characteristics that effective researchers develop. And honestly, every single one matters in real legal practice. First, they have to be prepared. Preparation means understanding the assignment, clarifying that issue, organizing your resources, and identifying jurisdiction before diving into databases just randomly. All right. Unprepared research wastes enormous time. All right. You have to be flexible. And honestly, this becomes incredibly important because legal research rarely unfolds exactly the way you're going to expect it to. Sometimes facts evolve, issues change, the controlling authority, it can shift, or the original legal theory falls apart entirely. All right. So a good researcher is going to pivot instead of panic. All right. Be thorough. Thoroughness matters. Legal professionals cannot simply stop after finding one favorable case and then just ignoring everything else. You're going to have to evaluate contrary authority and defenses and procedural issues and even jurisdictional limitations honestly, because judges and opposing counsel are definitely going to do that. All right. Be patient. Again, legal research can become incredibly frustrating. Searches fail. Cases are in conflict, authority becomes confusing, statutes, cross-reference, endless provisions, and honestly, frustration tolerance becomes part of the skill set, okay? So strong researchers stay methodical even when the process becomes difficult. So organization matters enormously in those situations, because without your organized notes, citations, case summaries, researchers are going to quickly lose track of authority and waste time. And it'll be about rediscovering sources repeatedly. Another important quality is efficiency. And efficiency doesn't mean rushing carelessly. It means the right tools, strong search strategies, and even logical research progression. So experienced researchers know where to start and how to narrow issues quickly. All right. Now, creativity may sound unusual in legal research, but honestly, legal analysis often requires creative thinking. You're going to have to draw analogies and identify emerging trends or apply older precedent to new technology, or to construct arguments where direct authority barely exists. That requires intellectual flexibility. You also have to be wary. All right. This is probably one of the most important qualities in modern legal research because misinformation, it exists everywhere. All right. Not every website is reliable. Not every summary is accurate. Not every AI generated response is correct. So strong researchers are going to verify the authority carefully. All right. So resourcefulness, it matters. Sorry, I'm just segueing through because I'm trying to get to the end. Sometimes the answer, it's hidden in a footnote or an annotation or a treatise or a conversation with some sort of, experienced colleague, right? Good researchers follow useful leads intelligently. And last but not least, remain calm. Panic destroys research efficiency faster than almost anything else. Legal problems often appear overwhelming initially, but strong researchers learn how to break apart those issues systematically, to analyze the authority carefully, and to move through the problem step by step. And that calm, analytical mindset is what ultimately transforms research from chaotic searching into that professional legal analysis. And honestly, that is really central, to this entire chapter. Effective legal research is not about magically knowing every answer immediately. It's about learning how to think, to organize, to analyze, and to adapt like a legal professional. So anyhow, as we kind of finish this chapter, I want you to understand, again, legal research, how do I say this? It's about learning how to think through uncertainty systematically, because it's a puzzle, right? The uncertainty is what makes a lot of people uncomfortable initially. And you have people who will often enter thinking that, expecting, not even thinking, they're expecting clear answers, obvious rules, straightforward conclusions, but it rarely works that way. Again, you have so many things that happen, like the case conflicts, the jurisdiction, disagreements, things like that. And again, you have to learn how to navigate all of that uncertainty, both carefully and professionally. And that's one of the biggest set shifts that students have to make. It's moving away from, I need to know everything immediately, which is so hard in the times of instant gratification, right? Strong legal researchers do not magically know every answer. They know how to identify issues. They know how to organize the problems. They know how to locate the authority. They know how to validate sources, and they know how to analyze competing arguments. And that is the skill set. All right. And honestly, one reason legal research becomes intellectually challenged is because it does require multiple forms of thinking simultaneously. You have to think both factually and procedurally and strategically and analytically and ethically all at one time. All right. So if you're researching a constitutional issue involving, say, social media speech and employment termination, right? Suddenly you're going to have to evaluate First Amendment doctrine and state employment laws and private versus public employer distinctions, maybe a retaliation claim, procedural posture, and then even conflicting appellate precedent. And that complexity is 100% normal. All right. And again, remember that legal research is very deeply connected to professional responsibility. So clients are trusting the legal professionals to provide them with accurate information, reliable guidance, competent analysis. And that trust matters a lot because legal errors can affect, families and employment and freedom, constitutional rights, financial stability, all kinds of things, right? Again, it's not some sort of abstract academic work. It affects real human lives. And this is the reason right here that research has to become, you have to be meticulous. You have to double check authority. You have to verify your citations, confirm your statutes, shepherdize your cases, and organize your analysis carefully. Not because of a demand for perfection, but because competence matters professionally speaking. All right. Let me think. Let me give you one more thing. So, students often will discover over time that legal research skills do transfer far beyond litigation because you have the ability to analyze problems, to identify this reliable authority, to evaluate the competing information, and to think critically under uncertainty. And all of that becomes very valuable when you're talking about business and government, and if you go into policy work or compliance, education, advocacy, there's so many fields, right? But the modern world is overloaded with information. So you have to learn how to separate the reliable authority from the noise, the credible analysis from unsupported opinions from, armchair lawyers on social media. Or even the actual evidence from assumption. And again, that skill is increasingly valuable everywhere. So again, remember that good legal researchers are not people who never struggle. All right. They're just people who learn how to work through confusion methodically instead of panicking when answers are just not immediately obvious. And that calm analytical process is what ultimately is going to transform you into a legal professional. And that's it. That's all I have for you. So let me know if you have any questions. Bye.